Oh, boy. All right. Let me see. Well, oh, boy. All right. Sorry, y'all. I don't have a call-in number. Not tonight. I'm going to try to get one next time. I'm checking my messages right now. Let's see. All right. Let me get me a bowl of water, y'all. I'll be right back. All right. People, I don't know why they always call me when I start trying to go live. They always call me. All right. All right. Sorry about that, y'all. All right. So y'all do me a favor, hit that like button if you don't mind. Also, on a scale of 1 to 10, how good can you hear me? I need to know that. Give me a scale of 1 to 10. Let me know how good you can hear me. Jerome, if you're watching tonight, man, I went and found that case you were telling you mentioned. I'm gonna see if I can find it on my. I think it was on a. It's on my YouTube channel. Give me a second. Let me find it. It's on one of my YouTube videos. I think it's on. It's a comment on this video. Let me see if I can find it. Let me go back some and see if I can find it. It was a couple of days ago. Let me just go to the video. Hopefully I can find it like that on the video. It should be in the comment section. Is it? I don't know. Is it on here? I don't see the comment on here. It must have got deleted. Did it get deleted or something? I'm not sure where it is. Let me go and check my messages. Let me go and check my messages, y'all. Give me a second. Manage videos. Community. Comments. I don't know what that is. Nothing is held. Okay. I don't know. I'm trying to find a comment, but I don't see it. I guess I don't know where it's at. It must have got hidden or something. I don't know, but I can't find it. I can't find it, y'all. Well, anyway, Jerome, he was mentioning about the case in Collins versus, I think it was Collins versus City of Chicago or City of Chicago versus Collins. He was saying that that I should read this case here. Hold on, where is it at? Is it this one? This case right here. I'm sorry about that, y'all, but he was suggesting that I read this case here, in which the Supreme Court, United States Supreme Court, basically held that the DMV's jurisdiction was essentially over interstate commerce. And it does say that. I have to go back and see if I can find it again. So what I went and did was I found this right here. This was the act. I didn't do a thorough analysis on this, y'all. So don't, I might, if I misquote something, I apologize. But I would just advise y'all to go and do your research on your own. But the dispute in this particular case, the so-called federal law, would be the Driver's Privacy Protection Act of 1994. So I went and found this case right here. Where is it at? Let's see if I can find it. I'm trying to find, because I tell you what, I'm gonna do it like this, and then I go back to the case because I want y'all to see what they're saying about the case. So this was I think this was a Third Circuit case. But if you look right here, it'll tell you that, for example, the Driver's Privacy Protection Act, Title 18, United States Code, blah, 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 regulates the disclosure of personal information contained in the records of state motor vehicle departments. So essentially, this so-called federal law is applicable, uniform throughout the states. And it is something that the Department of Motor Vehicles, whatever they call it, in your particular state, is subject to. So this is the case right here that I'm actually going to read right here from 2000. That's this case right here, Reno versus Condon or whatever. If you go up here, you'll see it. See right here, Reno versus Condon, or however you pronounce it. Where we at? That's the case. But let me go. I think it's a federal Third Circuit. The purpose of me showing y'all this is basically to let you know that the Driver's Privacy Protection Act regulates the disclosure of personal information contained in the records of state motor. What I'm trying to get you to understand is this is like if you have your so-called driver's license or whatever through a Department of Motor Vehicles, then they're essentially construing it under the Commerce Clause, if that makes sense. So let me show y'all what I'm talking. Let me go back here first and check and see how good y'all can hear me. Let me close this out. Let me go back to the video. Construing it, not this one. They want to talk to you. LeBron, you a trip, man. Let me see. Since it's just U.S. for now, how do you feel about using Rule 2 of the Federal Rules of Civil Procedure to raise the federal question of violating the rights of the individual being charged? Rule 2. Let me go and see what Rule 2 is. And then I'll probably better be able to answer that question for you. So let's go to Google. Federal Rule of Civil Procedure. Rule 2. One form of action. I'm going to read your question again just to make sure I understand it. How do you feel about using Rule 2 of the Federal Rules of Civil Procedure to raise federal question? So I kind of, to be honest with you, I don't kind of, it's a little difficult for me to understand your question. So if you don't mind, Daniel, can you reword the question? I'm sorry, y'all, I don't have a call-in number right now. I don't know why I didn't do it, but I should have had a call-in number for y'all. I'm sorry about that. But you're not essentially, you're not really. I mean, I guess you can say that, but you're not really. You're not bringing the lawsuit against them under Rule 2, even though they're saying one form of action. I don't like a lot of people. This just confuses people. There is one form of action. Like I think this confuses people, and people really don't know what they did. So I'm gonna see if it's in the rule. It might be in the rule because what this is what they did, man. Look, I've said this over and over and over. All right, the Federal Rules of Civil Procedure. Let me see if I can find a case and show y'all what I'm talking about because they did it all over the country. They did this all over the country, y'all. In most states, it's probably still separate in some states, but it's not in a lot of states. Most of them have already done it. And let's see. Right here. This is one of them right here. All right. So what they did, y'all, I guess I got to give some of y'all a history lesson. Let me see. Y'all hit that like button for me. All right. So essentially what they did, y'all, a long time ago, I don't know when they did it in your particular state or whatever, but courts of law, common law courts, courts of equity, chancery courts, admiralty courts, and maritime courts. Generally speaking, all of these so-called courts were separate. They had their own sides, their own rules of procedure. For example, in a common law court, they had the common law rules of procedure that govern how to prosecute cases under the exclusive jurisdiction of common law. If you were in a chancery court, then equity had their own rules of procedure. To be honest with y'all, this is already, it's documented. I can guarantee you it is documented all over the country within your so-called state. All right. So what they did was they merged, they've consolidated, they condensed all of the rules together. And they don't call it the common law rules of procedure or the equity rules of procedure or the admiralty rules of procedure. They just call everything now the rules of criminal procedure or civil procedure. That is what they call it now. For example, when everything was separate, if you wanted to litigate a case in equity, you had to file a bill in equity. A bill in equity is another word for complaint in equity. If you wanted to do it in common law, you had to file a declaration. A declaration is another word for complaint in common law. If you wanted to do it in admiralty, you had to file a libel. A libel is another word for complaint in admiralty. They don't call it a libel anymore. They don't call it a bill in equity anymore. They don't call it a declaration anymore. They call every damn thing a complaint. They merged every damn thing together. They consolidated, they condensed everything together. Right here, let me see. There has been since 1938 only one form of action, the civil action. Okay. Equity has a civil jurisdiction and common law has a civil jurisdiction. Well, admiralty do too, but they're attaching. They seem to be attaching some sort of so-called criminal penalties to it, and that's why they're treating it as criminal, aka quasi-criminal. That's what they're doing. So if you read, I'm gonna just skim through some of this stuff. The merger of law and equity under the Federal Rules of Civil Procedure, both a suit at law and a proceeding in equity are subsumed under the phrase civil proceeding. Rule 2. See this? Uses the phrase civil act. This is what they did. They condensed, they consolidated all this shit to just confuse you. But it doesn't confuse me because I know exactly what they did. And I know how to file a bill in equity. I know how to file a declaration. And I'm pretty sure I know how to file a libel in too. All of this stuff is easy. Let me go back here. Yeah. when they charge someone and they say it's criminal, it's a violation of the rule. They don't have standing. It's not, well, you're, what people don't understand, you're just in a territory. You're in a territory. So let me see if I can try to decipher this for you. For example, let's go. We're going to use a state for an example. I'm kind of getting off topic here, about, different from what I wanted to talk about. But let me see if I can show you what I'm talking about. So we're going to use let's use the Georgia. I'm just off the top of my head. The Georgia rules of professional conduct. All right. And we're going to see, let's go to, what is it, Rule 401, terminology, definition, competency, diligency. I'm trying to see if it's going to, well, let's go back here. Is applicable right here. All right. So we're only talking about Georgia right now. All right. Yes, Georgia lawyers are required to follow the Georgia rules of professional conduct. Now, these are just rules, okay? This is another form of law. It is a variation of law. It is a species of law. To anyone who voluntarily makes themselves subject to that administrative board called the Georgia Bar Association. All right. It ain't no different than a statute. You voluntarily made yourself subject to these rules. And so since you've done that, these rules, although they are only rules, but these rules have the same force and effect as law upon you. It's just like with the Georgia rules of, same thing with the judges. Georgia, let me see, right here. These canons right here. Now these canons would not have the force and effect as law on an attorney who is not a judge, who has not voluntarily made himself subject to these rules. Okay. And if a judge violates these rules, then he's going to be sanctioned. He's going to be punished, or he should be sanctioned or punished by the members of that administrative agency, that administrative so-called judicial board, because he violated these rules that have the force and effect of law on him. So this right here, this way, let me see, he says when they charge someone and say it's criminal, it's a violation of the rule. What is happening is this. It's a you can say it's a rule or whatever, but I just call it a bylaw, a corporate bylaw. That's what I call it, because that's what it is to me. It's a corporate bylaw because you're in a territory. So a lot of people, I don't know how many times I have to tell this to people, but if you are in an incorporated city or an incorporated town, you are in a territory, because that so-called incorporated city or town has gotten a corporate charter from the legislature to act like a government, to perform government functions. All right, but before they did that, the legislature, they don't have jurisdiction over that land. They can't. The land isn't theirs, so they can't exercise jurisdiction over it, because that constitutes, to some certain degree, a taking. And you can't take private property and use it for public purposes like they're doing with a municipality. You can't do that. You can't do that. So the people who own the land and applied for that corporate charter, they voluntarily did that and made that particular geographical area of land subject to the territorial jurisdiction of the legislature. And once they did that, statutes then became and had the force and effect of law. It is a species of law. It's a variation of law, but it is not law in the sense to where it is applicable to everybody, because it's not. Okay. Let me see. I'm not sure if I answered that question. They don't have standing. Let me see. Well, they do have standing. I'm gonna tell you that right now. But you're in a territory. You are in a territory, and corporations have to enforce their own rights. So when they bring you to court and file these so-called criminal charges against you, they're filing a lawsuit against you. They're enforcing their rights. They're not sleeping on their rights. But what they're doing is fraud, to be honest with you, because they're really not telling you what's going on. Y'all hit that like button for me. They're really not telling you what's going on. They already don't want to tell you what the nature of the action is. Or prove to you that you are a corporator or a subject or a thing that is subject to their corporate territorial jurisdiction. It's really just a presumption. And I'm not gonna lie, it seems like overall it's a reasonable presumption, although it's wrong. You can be wrong and still make reasonable presumptions. The reason why I say that is because you're over there, you have a so-called driver's license, you have a so-called motor vehicle with a damn VIN number on it. Your car, your so-called car, is an article of interstate or intrastate commerce. At least that's how they're construing it. You already have the driver's license, you have the insurance, you live in the territory. Your kids go to school over there, so it seems like they're deeming you all of these things, such as a dependent, a surety, a corporator, a subject. That's what it seems like to me. That's what it seems like to me, because if you're in a territory, the territory in and of itself is a dependency of the legislature. Let me show y'all what I'm talking about. This is what they say. Territories are mere dependencies of the let's see. During the time of the appropriate territory, they are mere dependencies of the United States. Now I want y'all to just pay attention to. Let me go off here and do a parallel search. All right, this helps. I want y'all to pay attention to this. This is all over the country. All right, you see Ohio, you see Texas, you see Indiana, you see New York. It's the same shit, y'all. Same shit. Territories are defined to be mere dependencies of the United States exercising delegated powers. All right, so let me read this to y'all again in another way. Municipal corporations are defined to be mere dependencies of the state legislatures exercising delegated powers. A city is a municipal corporation. A county is a municipal corporation. A town is a municipal corporation. This is what the fuck they're doing. The Supreme Court of the United States has fixed the status of territories as mere dependencies of the United States and has declared that their people do not constitute a sovereign power. Did y'all see that? So let me read this to y'all again, even though it doesn't say that, but I can, based off what it says, I can reasonably conclude what I'm about to say. The Supreme Court of the United States has fixed the status of municipal corporations as mere dependencies of the state and has declared that their people do not constitute a sovereign power. Is this making sense for y'all? What are they talking about? If it were granted the court certain rights, powers by the statute. Go down. All right, here, what is this? Virginia. It's retailing, but all but one county preserving, blah, blah, blah. It's very important to reach down. Let me see right here. This is inappropriate. I'm not going to I don't know what they're saying inappropriate, but they're going to tell you essentially what a county is or whatever. This is not inappropriate, since the counties themselves are entirely creations of the legislature with their boundaries set by statute, not by constitutional mandate. So on and so you're in a territory. It's a city is a territory. A county is a territory. An incorporated town is a territory. What they're not telling you is, all right, a city, town, and county is also an administrative agency. That's what the fuck it is. They're administering their corporate charter that they got from the legislature. That's what they're doing. Nah, they're using administrative. Well, yeah, I agree with that. You're right about that. If you construe civil to mean contractual by agreement, civil law is voluntary, or at least presumed to be until you properly rebut that presumption. I can agree with that. Part of that agreement is punishment for breaking your agreement called criminal aspects. This might be some stuff I need to go and study some more. Each department has rules that fall under administrative law. I can agree with that. Contracts that are unlawful. I can agree with that. They're either expressed or implied contracts. I can agree with that. Not if you don't rebut the unlawfulness. To sue anyone in the name of the state, they don't have standing in a civil or criminal. Sue whoever that's bringing the charges. I don't know why. For some reason, it's doing something to your comments line, and I don't have time to. I don't have enough time to read it because it always disappears when I try to read it. So I'm not sure why it's doing that, to be honest with you. There is nothing lawful about withholding it. I can agree with that. That's fraud. I can agree with that because it's like it's robbing you of what is it? What's the candor? It's robbing you of candor. It's robbing you of sufficient consideration because how are you going to adequately consider an offer when all of the terms are omitted? Some of the terms are omitted, and you never even considered them in the first place. So I can agree with that. Hit that like button for me, y'all. I definitely agree with that. Just pointing out that the court will assume everything is legal if you don't speak up. Yeah, they will. Yes, they will. Let me see. Where was I? I think I went. No one can sue in the name of the state, civil or criminal. I think they're suing. I think they're suing in a It's in a corporate capacity. It's not really in a sovereign capacity. Unless it's over a subject or corporate or a thing or a dependency or something like that within their territorial jurisdiction. If you notice, when they do sue you, they always do it under a statute, man. Generally speaking, it's going to always be under statute in one of their administrative courts, so-called courts. That's what they're doing. They're enforcing public policy when they file these lawsuits against you. That's what they're doing. But notice that they're only doing it in a territorial court with an executive administrator sitting on the bench acting like a judge. That's what they're doing. No one can sue in the name of the state, civil or criminal. Do you have any can you like off the top of your head, can just give me some case citations in support of that? Because I disagree, but I'm not a guru, okay? I make mistakes all the time. So I can understand, I don't even care if I'm wrong. You know what I'm saying? It's not a big deal to me that I'm wrong. I don't want to mislead anybody. But I just disagree with that. The 14th Amendment allows the state to sue and be sued. I agree with that. I agree with that. I agree with that. No, I want you to notice that the jurisdiction that they bring these laws. Let me show y'all something, man. Let me see. If it's gonna be in here. Let me see if I can find it. I might have typed it wrong. I'm not really sure. Corporations could not. It's I don't know what it is. I might be doing it wrong, y'all. Terminated, blah blah blah. A common law corporation could never sue or be sued after dissolution. A common law corporation could be sued only in the courts of the sovereignty of its origin. I might be typing it wrong. And explain on the common law. I think I might be typing it wrong. What I'm trying to find. I don't want to spend too much time on it. Go back and see what the questions are. Because I think it's the name, Lionel. I think the name is throwing you off by calling it the state. I don't care if it's called the goddamn the state of all the states in the world. The name doesn't confuse me because I know it's a damn corporation. You're in a territory, man. You're in a territory, and in the territories, the so-called government, they are sovereign over there because the territory itself is a dependent. It's a dependency. The territory itself is a dependency. And everything over there is a dependency. And everything over there is it was either created by the legislature or somebody or its status was changed and made it subject to the territorial jurisdiction of the legislature. It has to be. That's the only way. That's the only way that I know to make sense of this, because the creature cannot usurp or cannot rule the creator, and the people are the creator. But what they did was when they created these territories, it switched the roles, and the legislature became the creator then, and the territories and everything, generally speaking, within the territories became the creature. Have you seen where they were trying to allow corporations to vote in Delaware? To be honest with you, if they want to allow them to do that within their territories, I think they can. They're probably not going to do it, but if they want to allow them to do that within their territories, they probably can. I'm of the opinion that they can. Hit that like button for me, y'all. But no, I didn't see that. You talking about voting like in actual elections for like to change the state constitutions and all that shit? They probably, well, I don't know. They probably wouldn't be able to do that, just to change the state constitution. But I could be wrong. But corporations are citizens. I'm not sure if y'all know that, but they are citizens. Legal definition for the word person in the 14th Amendment is how? Oh, okay. Yeah, I can agree with that. A person is a corporation. Yeah. The problem with the 14th Amendment is it does not give you a definition for the word person. So I'm not sure if the judiciary has defined it or not, because I haven't read any cases on it. I haven't really looked for any either. But generally speaking, it seems to be they omitted that definition. Can I sue you for damages due to someone else? Maybe. You probably can, because a third party debt collector can sue you if they buy your debt. Then they have a claim. They bought your claim from somebody else. But the problem with that is they really won't have any I mean, they're not witnesses. They're not credible witnesses because essentially what they're saying is just hearsay. Hearsay within hearsay. They don't have firsthand personal knowledge of nothing. They just bought a claim from somebody and they're trying to go to court and file a suit on the claim. They're going to act like they're the holder in due course. I'm of the opinion that holder in due course means holder in due course of the law. I could be wrong. I'm just freestyling this off the top of my head, y'all. I'm trying to make sense of this. So let me see. Holder in due course of means due course of the law. I'm just freestyling this, y'all, because I really don't even know if that's what it means. I'm gonna see if they're gonna tell me. Ninth Circuit. Well, I guess I was wrong. A holder in due course means the holder of an instrument if blah blah blah. Anyway. Right here. When I just told, let me see. Oh, okay. Well, that's good. That's good, Lana. I mean, if you don't mind, you could. I mean, you could if you want to. You can probably send me something. I can probably check it out. You know what I'm saying? Look. I'm not a guru. I don't know how many times I have to tell y'all this. I'm not a guru, and some of this stuff I don't even know. I just be freestyling this stuff off the top of my head based off cases that I've already read. I just make reasonable conclusions off of that, but I could be wrong. Let me see. No, so they can't either. If you understand what, if you understanding what's saying, I think they can. I could be wrong, but I think they can because if you buying a claim from somebody, unless certain claims you can't buy and enforce in court, But I could be wrong. They are operating in a commercial capacity and a proprietary nature without full disclosure. Usually are operating in commercial. I can agree with that. I agree with all that, Chip. I really do. I agree with that. The state creates pretty much all statutes from regulation of commerce. They are claiming you violate interstate commerce by shooting. Yes, they are. It's a presumption. They're not. The problem with it is the terms. Most of the terms that I've seen, they're commercial in nature. The terms that I've seen: possession, traffic, motor vehicle, carrying, trafficking, stuff like that. Let me see. But the problem is it's a presumption. And you don't rebut the presumption. But even if you do rebut the presumption, they're gonna act like they don't know what the hell you're talking about. So yeah, it can really go both ways for real. But yeah, you're right. Yes, I was referring to corporations voting in elections. They were talking about how a corporation could vote, then the owner of the corporation could then go vote again individually. Oh, that's crazy. Yeah, that's crazy right there. But believe it or not, if they wanted to allow them to, they can. Because if you can make human trafficking legal, which is it was, and lawful, you can make any damn thing legal or lawful. Because slavery was human trafficking, and it was lawful and legal. So what? Like, yeah, you can do that. It don't surprise me at all. Does not surprise me. Okay. They aren't calling. They aren't acting like they don't know. No, no, I disagree with that, Steve. I'm telling you what I've had a lot of experiences with these people. Now, some of them probably don't know. All right, but some of them that I have asked, they're acting like they don't know. So I disagree with you on that. I disagree with you on that. Y'all hit that like button for me. I'm glad you got a chance to catch this live though, Steve. You can I'm sorry I don't have a call-in number this time, man. I'm sorry. Um, I mean, if you can ask your question here, and I'll try to get to it. If y'all want to, I'll be here until 8 o'clock, so y'all can send me some documents or something if you want me to look at it or whatever, and I'll try to give you my input on it or whatever. And then I'm pretty sure there's some people out in the comment section. They're probably going to comment on it as well, and they could probably help as well. Yeah. Yeah, 'cause I forgot about that. My bad, SG. Um, I think it was. This is what I was talking about. He was talking about the Drivers Privacy Protection Act right here, where it says regulates the disclosure of personal information contained in the records of state motor vehicles. And then they cite the case that I'm about to just show y'all what they were talking about. So right here, this is what the federal government is arguing. The purpose of this act is. Yeah, what they're saying is what the federal government is arguing is that Congress essentially it operated or it enacted this legislation within the ambit of the federal constitution, if that makes sense. So in other words, they're saying that this was a rightful exercise of legislation, or a rightful enactment of legislation by Congress. So this right here, I'm gonna read y'all this. The Drivers Privacy Protection Act of 1994 regulates the disclosure of personal information contained in the records of state motor vehicle departments. We hold that in enacting this statute, Congress did not run afoul of the federalism principles enunciated in these cases right here, which is New York versus United States, 92, and Prince versus United States, 1997. All right, I'm not gonna read this whole thing. Y'all can go and read it if y'all want to. The DPPA, which stands for Drivers Privacy Protection Act, regulates the disclosure and resale of personal information contained in the records of the state DMV. I didn't even know they was doing this stuff, y'all. When I read this case, I was kind of shocked that they were doing this. State DMVs requires drivers and automobiles owners to provide personal information, which may include a person's name, address, telephone number, vehicle description, social security number, medical information, and photograph as a condition of obtaining a driver's license, a tax, by the way, and registering, surrendering, or whatever, if that makes sense, an automobile. Congress found that many states, in turn, sell this personal information to individuals and businesses. I didn't know they were doing that. These sales generate significant revenues for the states. See Travis versus Reno, 163 Fed 3rd, page 1000, 1998, noting that the Wisconsin Department of Transportation, which is an administrative agency, receives approximately $8 million each year from the sale of motor vehicle information. This is the DOT. This is the federal. Well, that's not a federal DOT. This is a state DOT. Let's go down. All right. The United States asserts, first off, the United States cannot assert shit. It's a fiction. What it can do through its agents, because it's a fucking corporation. Notice they keep saying the United States. The United States asserts that the DPPA is a proper exercise of Congress's authority to regulate interstate commerce. Under the Commerce Clause, United States Constitution, Article 1, Section 8, Clause 9, blah, blah, not Clause 9, Clause 8. Now, let's see. The United States bases its Commerce Clause argument on the fact that the personal identifying information that the DPPA regulates is a thing in interstate commerce, and that the sale or resale of that information in interstate commerce is therefore a proper subject of congressional regulation. This is what the federal government is arguing. United States versus Lopez, yada, yada, yada. We agree with the United States contention. The motor vehicle information, which the states have historically sold, is used by insurers, manufacturers, direct marketers, and others engaged in interstate commerce to contact drivers with customized solicitations. The information is also used in the stream of interstate commerce by various public and private entities for matters related to interstate motoring, because drivers' information is, in the context, an article of commerce, like your damn car. I would go so far as says the damn driver's license itself is an article of commerce, as evidence that you are maybe engaged in transferring or trafficking or moving or transporting articles of commerce, something like that. Its sale or resale in the interstate. Its sale or release. I'm sorry, y'all. Into the interstate stream of business is sufficient to support congressional regulation. We therefore need not address the government's alternative argument that the state's individual intrastate activities in gathering, maintaining, and distributing drivers' personal information have a sufficiently substantial impact on the interstate commerce to create a constitutional basis for federal legislation. Yada, yada, yada. I mean, that's all I'm going to read. But yeah, it does hint at the DOT and at the Department of Motor Vehicles. I don't know why they're trying to distinguish the Department of Motor Vehicles from the Department of DOT. Like, that shit makes no sense to me. That's what they're trying to do, though. I don't see how you can distinguish. Both of them are administrative agencies. So I guess that what they're trying to say is the Department of Transportation regulates interstate commerce and the Department of Motor Vehicles regulates intrastate commerce. They trying to suggest something. Not sure what the fuck they trying to suggest, but they trying to suggest something. But that don't make no sense to me. It makes zero sense to me. You can try to hide this shit all you want, but it just don't make sense to me. Congressional record, June. What is that? Congressional record, June 13th, 1967. They are separate in my state. No, DOT for roads, DMV for licenses. Well, I mean, I have okay. I can understand why you're saying that, Steve. But I have a Class A CDL. I still have it. And when I was traveling all over the road, all over the country, I would have to pull in, not all the time, but it wasn't frequent, but it wasn't rare. I would have to pull over for DOT, and they would have to, inspect my truck, make sure everything was good, yada yada yada. You know what I'm saying? So they ain't no different than the Well, you know what? I don't think the Department of Motor Vehicles has a so-called law enforcement aspect to it. The DOT does, if I'm not mistaken. But it's still the same damn thing though. So they just doing different shit. But it's pretty much the same damn thing. It's just that some of them has the authority to do what others don't, if that makes sense. But it's an administrative agency. They're taxing people for licenses, and they're regulating they're regulating interstate and intrastate commerce. That's what the fuck they're doing. They can look, man. They can hide it all they want. They can lie about it. You can argue with me about it all you want. I just disagree with it because I've studied this long enough to know, and I've tried it enough times in so-called court to know that they're hiding something and they're lying. And I've read too many cases that tells me that they're lying about it. Congressional record, June 13th. What is that? I'm gonna see what that is. What is this? Eligibility leads MCSAP agencies for state and territories. Formula grant provides financial assistance to state and local law enforcement agencies to increase CMV related enforcement in South. What we got? Congressional record, June 13, 1967. Let me see what that is. June. Motherfucker pop right on up. Let's see. Bond edition. Let me see what this is. All these damn text messages. All right, I'm trying to see what it is. $198. This has to be some sort of act, research, development, and evaluation. So this is okay. These must be the minutes of what they did. Let me see. We, the members of this body, conscious of blah 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 blah. This great republic, unite in praying for thy guidance as we faithfully endeavor. A message from the Senate. What am I looking for? A call of the House. What am I looking for in here? I'm trying to. This is a lot of reading. I'm not sure what it is. It doesn't look like an act. It just looks like, they had a meeting and this is what was discussed in the meeting. It's like this is like their minutes as to what was said and what was done at the at this meeting. I don't know. Let me see the Navy. I'm not sure what that is. Let me go and see if he can tell me what it is. Different agencies for different government functions, different specialties. You don't want regular drivers having to jump through regulations intended for commercial traffic. All of it is commercial. They're construing it all commercial. But I get what you're saying, Steve. And I'm in agreement with you as well. I'm not disagreeing with you, but I get it. But it's all commercial. They're deeming everything commercial. Any large organization breaks into smaller groups to specialize. I don't disagree. They are the same in the big picture. CHIP, it's all contract. Look it up. Specify resident congressionally directed working group to develop new funding formula for Federal Motor Carrier Safeties Act grant program. Washington, the U.S. Department of Transportation today announced the formation of the motor carrier. They are I mean they separate here too. SG, I forgot to tell y'all that they separate here too, but I mean they pretty much the same damn thing. You know, you go to the Department of Motor Vehicles to get your commercial driver's license. I did, you know, at least I did. Maybe in another state they might do it different, but I had to come down here and get mine when I was driving all over the road. I had to go to the same Department of Motor Vehicles that everybody else go to. So the only distinction is they just put commercial driver or something like that on your license, but it's the same shit because you're still a driver. The definition of driver does not change just because you have a commercial driver's license and a regular driver's license. The word driver still means the same exact damn thing it meant over 100 years ago. I don't give a damn how the legislature changes that definition to make it misleading. They can't make that definition beyond the scope in which the common law meaning or its ordinary meaning is intended, because you violate due process. That's goddamn usurpation. You can't do that, but that's what they're doing. It's what do they call it, ultra varies or something like that. So they're enforcing these regulations, so to speak, beyond the scope in which they are intended, or in other words, beyond the scope in which they can lawfully be enforced. I think that's a better way to say it, because they can't do that, to be honest with you. I'm just going to tell you. I'm pretty sure some of y'all already know that, but they cannot do that. They can't do that. They can't violate your rights at the same time while enforcing their rights. They have to have a compelling public interest or something like that for it. And they really can't do it. But you over here, you're in a territory. Everything over here is a dependent. Everything over here is deemed a corporator. Yada, yada, yada. Why would anyone want to agree to a privilege when they already have a right to travel in whatever? Yeah, I agree. I completely agree. I agree. Same as the appearance that the state of is one of the several sovereign states. Now, it's a corporation. I don't see state of nowhere in no state constitution. Well, not no state constitution, in the federal constitution, but it's a territory, man. I don't know what else to call it but a territory. That's all I know, because they're enforcing statutes. They're following statutory procedures. The so-called state of is acting like they're sovereign, and you're not. You know, when you file appeals, you do it under a statute. When they file claims against you, lawsuits against you, they do it under a statute. When you filing, writs, writ of certiorari to the Supreme Court of the United States, it's under a statute. All statutes, all legislation is territorial. That's right, Steve. You don't have the right to drive on the roads without a license. No, you don't. You have a right of locomotion to move from one place to another in any mode that is consistent with the I don't know which principle is, but it's consistent with a principle in common law and equity without being taxed. Yes, you do. So if you disagree with me on that, then I disagree with you. Which I don't mind. I don't care about you disagreeing, but yeah, I know exactly what you're talking about. The cases that people cite that the Supreme Court say that you don't have a right to drive, operate a motor vehicle. They're right, because I know what a driver is. I know what a motor vehicle is. They can mislead y'all all they want. This shit don't work on me, Because I know exactly what they're doing. I know exactly what the hell they're doing. And I'm telling you right now that you do not need a license to exercise your right of locomotion in any mode that you want, just so long as you do it in a safe and reasonable manner. And even if you did not, even if there were no statutes requiring you to do that, you still had to do it. And if you violated that, then obviously equity would come in, and they would probably you would probably get an injunction against you, probably to never do it again, or to just take your privileges away or something like that, or then restrict your privileges or something like that. They can trick some of y'all. They're not tricking me with this stuff, man. They ain't tricking me at all. 63. Okay, he got it. Okay, let me see what it is. I'm gonna look it up over here. 14th Amendment. Oh, okay. I see what you're talking about now. This is interesting, to say the least. Tax to travel. They can't tax you for traveling unless it's like if you're using the roads. I think it's reasonable for people who are actually using the public highways, for private gain. I think that's reasonable to tax them for doing it, because like they're actually using it for money and stuff like that. I mean, to make money. I think it's reasonable, but what do I know? That's just me. Since I don't disagree, you can't be traced for traveling. Whatever word you want to use for operating a vehicle. You see that? You see these words, right? You got to be careful with these words right here, man. Operating a vehicle. Operating a vehicle. These are all commercial terms, man. But I get exactly what you're saying. So please don't take any offense to what I'm saying. I do get what you're saying, but these are commercial vehicle. Man, look. A bicycle is a vehicle if it's used for commercial purposes. A damn scooter is a vehicle if it's used for commercial purposes. A horse and carriage is a vehicle if it's used for commercial purposes. Your body could possibly be deemed a vehicle if it's used for commercial purposes. A damn skateboard, rollerblades, or something like, they can probably deem all of that as a vehicle if you're using it for commercial purposes. I'm not saying this. I'm not saying the state doesn't have a right to tax, you for that. I agree with that, but they cannot tax you for exercising your right of locomotion in any manner that you deem fit, just so long, as you're doing it safely and stuff. They can't tax you for that. They're gonna tell you they can, but they can't. Today they'll tell you that they can, but if you go and read the old cases, no, they can't do that, fam. They can't do that. You can't tax rights, because if they're allowed to tax you for simply driving down the street, but you have a right to use the public highways, there's a contradiction right there. Not only that, but let's just say that they're allowed to tax you, for just using the public streets. If they're allowed to do that, then they're allowed to require you have a license just to walk down the damn streets. That's what that case was talking about that I read y'all the other day. They can't do that. They can't do that, man. This man, look, this don't go over my head. Let me go and read that right quick. Give me 1 second, man. Sorry about that. I'm gonna go and read what you were talking about. Was it Google? I'm not sure if that's the correct. I don't know if that's the correct one that comes out of it. I'm not sure if this is the correct section. Let me see. The 14th Amendment is unconstitutional. The purported 14th Amendment to the United States Constitution is and should be held to be ineffective, invalid, null, void, and unconstitutional for the following reasons. The joint resolution proposing said amendment was not submitted to or adopted by the Constitution of Congress, Article 1, Section 3, and Article 5 of the Constitution. The joint resolution was not submitted to the President for his approval, Article 1, Section. Oh, so they're saying the manner in which it allegedly passed violated the Constitution. The proposed 14th Amendment was rejected by more than 1/4 of all of the states then in the Union, and it was never ratified by 3/4 of all the states in the Union, Article 5. Okay, so they're saying it violated numerous articles in the Constitution. The U.S. Constitution provides, Article 1, Section 3, the Senate of the United States. Those days keep saying the Senate of the United States. United States. What y'all talking about? Shall be composed of 2 senators from each state. I don't know what these people talk. When I start seeing words like this, I just get scared because I don't know what the hell these people talking about. Article 5 provides no state without its consent shall be deprived of its equal suffrage in the Senate. The fact that 23 senators had been unlawfully excluded from the U.S. Senate in order to secure a 2/3 vote for adoption of the joint resolution proposal. Where is this coming from? He says this is coming from. Let me see something. Because if this is in the correct section, then it should be in here. So let me see if it's in there. Whoops, I don't need that. I'm tripping. This is what 198 pages. It must be something else because it doesn't, unless they took it out of here. But the word 14th is only in here one time. Yeah, unless they took it out of here. It's not in this one. This is from June 13th, 1967. So they probably gave you the wrong citation because it's not in this one. And sometimes that does happen. You know, it'd probably be in the wrong spot. Cause I see cases like that sometimes too. That I don't know who. Like sometimes the judges will actually cite the wrong damn case citation. Sometimes they do that. I'm not trying to put you on blast or nothing like that. But when I find stuff, I just want to be accurate. So when people go to it and they look, like for example, if somebody would have went to this section and looked and try to find that, they'd be like, that doesn't say that. You made that up. This is fake. Yada yada yada. You know what I'm saying? You want to avoid all that. You want to already have this shit in their face where they can see it, so they'll shut the hell up. That's what I was trying to find. I think I'm gonna do some research on that and see if I actually can find it. And if I can, I'm gonna give y'all the correct citation one day if I can find it. But that wouldn't surprise me though. None of that shit surprised me. A payment is the fulfillment of agreement. Have you seen any effect in state courts with Chevron deference being stricken by the Supreme Court. No, I haven't. I haven't really been paying attention to it for real. And then I don't know what the changes are that actually taking place. I don't really know what they are. You can use the public highways as a passenger in a car or any other mode of transportation. A license is required to use the vehicle because you represent a hazard. No, you don't. That would be inaccurate. That is inaccurate. As a matter of fact, that's a violation of due process. How the hell are you gonna presume something is a hazard? Just presume it's a hazard. If that's the case, then they can presume that everybody with a gun is violent. Like, no, that makes zero sense to me. That's a violation of due process. You can't assume facts not in evidence. That makes sense. That's essentially making a claim, an unsubstantiated claim. A license is required to use the vehicle, unless you're talking about a vehicle for commercial purposes, if that's what you mean, because you represent a hazard to. No, you don't. No, you don't. Cars are not, they're not dangerous. Human beings are not inherently dangerous. Don't take this the wrong way either, Steve, by the way. I know, but please don't take that the wrong way. But no. No. So I probably need to go and read that case too, because city, I know it's a Illinois case, but that is a principle in that case. Yes, for drivers of motor vehicles. Yeah, I agree with that. See, your problem is you don't know what a driver is. You don't know what a motor vehicle is. You don't know what an operator is, because you're going to read these statutes that the legislature intentionally they're hiding this shit is what I'm trying to say. They're trying to mislead you. They're misrepresenting to you these definitions. That's what they're doing. I don't care what they say a driver is. I don't care what they say a driver. Okay, yeah, that's good, man. That's good. But I don't care what they say a driver. I know what a driver is. They can change it all they want, but it's still going to. This is why when they start infringing on private rights, they have to have a compelling public interest. And since they have to have a compelling public interest, they have to strictly construe the statute. So in other words, even if the statute is misleading, they have to apply the ordinary and usual definition of the meaning of the word. They're not going to do that. They are not going to do that, because if they did, they would tell you what a driver is. I know what a driver is. It's part of the U.S. Constitution, not the Constitution for the United States of America. A commercial motor vehicle is defined as any motor vehicle used on a highway, interstate commerce, blah, blah, blah. The Fed's going, generally speaking, the Fed's going to get it right. There's a constitution within the Constitution. I can agree with that. It wouldn't surprise me. I've never really seen that, but it wouldn't surprise me. Passenger is someone paying to be transported. That's a commercial. Yes, it is. That is exactly what it is, SG. Blah, blah, blah. Let me see. Yeah, I had the number of the page number. It's like, damn, that's a lot of pages. Do you mean like 15,000 pages? That is a lot of pages. Ooh, that's a lot of pages. Court rulings have said automobiles are not inherently dangerous. The license is permission to use the public roads as a place of business, and commercial vehicles are taxed for damaging the roads. That's not the only reason that they taxed either. The case tells you why that they were taxed. They have to tax you for that, because if they don't, then if they wait too long, they can be collaterally stopped from bringing a claim against you from exercising, from using that road. They have to do that. Equity is going to stop them if they don't. let me tell y'all something, man. You know what? I don't even want to. I don't even know why I'm bringing this back up, but I guess I got to go back and do it again. But I don't even know why I'm bringing this up. I'll get back to y'all questions. Just post your questions. I'll get back to them. All right, look, man. I'm gonna read this again. I want y'all to pay attention to this, man. The streets and alleys of a city are held in trust, which means the municipal employees of that corporation are trustees. Anyway, the streets and alleys of a city are held in trust by the municipality for the use of the public, for purposes of travel thereon, and as a means of access to and egress from buildings abutting thereon or lots adjacent thereto. The right to travel on and along the streets of a city belongs to the general public and does not belong to its denizens alone. The right to travel being in the general public everywhere, the judiciary back then did not fail you. They did their damn job. All persons, look at this, persons have a right to pass along and use the streets and alleys of a street in all their parts, the full width and length thereof. The municipality, let me see it, the territorial corporate municipality, which is a mere trustee of the public and holds the streets and alleys in trust for the public, cannot deny the right of the public to use the streets and alleys. It cannot assume an exclusive ownership and deny the rights of the beneficiaries under their trust. You violate the trust when you do that. You breach the trust when you do that. They're violating their fiduciary duties. The corporation, the corporate territorial municipality, cannot assume an exclusive ownership and deny the rights of the beneficiaries under their trust and arrogate to itself a power greater than that of a mere trustee. We didn't talk about that. That was not a part of the agreement. That was not a part of the trust. And prevent the use of the streets and alleys by individual members of the public. The right of the public to use the streets is the right to use them for purposes of travel in the recognized methods in which the public highways of the state are used. Any method of travel may be adopted by individual members of the public, which is an ordinary method of locomotion, or even an extraordinary, in other words, commercial method. If it is not of itself calculated to prevent a reasonably safe use of the streets by others. Notice that they're not citing a statute in here for saying that. They're citing a principle in equity. Let me show you this principle in equity that they're citing. Because even if there were no statutes, there would still be laws, because statutes are not laws, except over in the territory. I think it's should be section 51. It's not it. Right here, 50. This is what they're talking about. This is equity and a common law maxim. So use your own as not to injure another. This is what they're talking about. While this is a common law maxim, it is often applied in equity. The Chancery Court frequently enforces this maxim by enjoining the erection or commission of nuances to the complainant on the land of the defendant, because although a man may own the land, he has no right. Let me rephrase that. Because although a man may own his horse and carriage, he has no right to so use it as to prevent his neighbors from enjoying from enjoying his or traveling safely down the road in his. Is this making sense for y'all? A man may be driven from his home. A man may be driven from the road by bad smells, or a reckless traveler, unbearable noise, shocking spectacles, and other intolerable nuances upon his neighbor's land. I know it's kind of confusing, y'all, so I'm just gonna read it for what it. I'm gonna read it as it actually. I'm gonna read what it actually says. Is what I'm trying to say. But I'm trying to get y'all to, when y'all see this stuff, even though it does not expressly say it, it implicitly says it. And you need to be this. That's how you need to read this stuff. A man may be driven from his home by bad smells, noxious vapors, unbearable noise, shocking spectacles, and other intolerable nuances upon his neighbor's land quite as effectually as though driven away by physical force. A man cannot so divert a stream of water, just providing the context, on his own land as to turn water injuriously upon his neighbor's land. You can't do that. And he cannot dig so near the land of his neighbor as to cause the latter, his neighbor's land, to cave in. You cannot do that. Or so near as to endanger his neighbor's wall. He cannot pollute a stream that flows through his neighbor's land, nor can he so stop or change the current of a stream as to prevent its ordinary flow through the land of another. A creditor, having his choice of two funds, ought to exercise. You see this? Ought. This is what you ought to do when you're traveling down the roads. You ought to exercise care when you travel. You ought to be careful. You ought to pay attention when you're on the road. You ought to travel at a safe speed. Is this making sense for y'all? Anyway, a creditor, having his choice of two funds, ought to exercise his right of election in such a manner as not to injure, or in other words, a traveler ought to travel down the public highways in such a manner as not to injure others. Is this making sense for y'all? All right, let me get back to it. Right here. A creditor, having his choice of two funds, ought to exercise his right of election in such a manner as not to injure other creditors, who can resort to only one of these funds. And it may be laid down as a general rule that no one can so exercise a right as to impair the right of another. This is what they're talking about. Nobody can do that. This is when I say the government cannot enforce their rights while simultaneously violating your rights. They can't do that. For example, when the police seizing evidence from you, but they seize that evidence from you in a manner that is contrary to the Fourth Amendment, they violated the Fourth Amendment while they were simultaneously seizing that evidence from you. And your remedy is, because they violated this principle, this common law principle and this equity principle, your remedy for that is to exclude the evidence. They don't get to use that evidence. They can't even bring it up. Can't even bring it up. Anyway, and it may be laid down as a general rule that no one can so exercise a right as to impair the right of another, especially if the latter is of equal dignity in the sight of the law. Like the same thing with this is what I be talking about when they say the federal government says you have a right to interstate travel. The right to interstate is the same damn thing. It's no different than intrastate travel and interstate travel is the same damn thing. The same damn thing. But the feds, I don't think that they can come in and tell the limit the states what they can do into, well, I don't know. I take that back. I don't know. I take that back. The feds probably can come in and do that. But the right to interstate travel and intrastate travel is the same damn thing. It's the same damn thing. These rights are of equal dignity in the sight of the law. It's the same damn thing. Anyway, let me see. The rights of life, liberty, property, and the pursuit of happiness must all be so used. Pay attention to this, y'all. I'm gonna say it in another way to kind of make y'all understand this. The people's rights of life, liberty, property, and their pursuit of happiness must all be so used and exercised as not to impair or injure the equal enjoyment of these rights by other people. Does that make sense? The Chancery Court will, on due application, enjoin the defendant from so using his property or so exercising. I'm going to read this again in another way. The Chancery Court will, on due application, enjoin the people, or a people, single or plural, from so using his or her property or so exercising his or her right as to injure the property or rights of another people, singular or plural, man or woman, same damn thing. Is this making sense for y'all? This is what they're talking about. No, they can't do that. Anyway, back to it. Any method of travel may be adopted by individual members of the public, which is an ordinary method of locomotion, such as a horse and carriage, walking, traveling in a car alone, whatever you want to call it, or even extraordinary, doing it as a place of business, if it is not of itself calculated to prevent a reasonably safe use of the streets by others. If a right exists in a corporate territorial government, aka city, county, town, or whatever you want to call it, to impose a tax on every person using wheeled vehicles thereon, it may in like manner impose such a tax for such use of the streets in every other manner of locomotion or travel, and reach the man on horseback or the pedestrian walking down the damn street. No, they can't do that. No, they can't do that. The right conferred on the city council, the right conferred on the corporate territorial government by the legislature to regulate the use of the streets and alleys of the city did not contemplate a power in a trustee of a beneficiary to deprive that beneficiary of a right. And even if the legislature did authorize them to do that, that is patently unlawful. They can't do that. Not saying they won't do it. I'm telling you, they can't do it. Let's see. Under the memorandum of law on the right to travel, I remember that. Utah Constitution, Article 118, no bill of attainder ex post facto law contract shall be passed. Collins' case is addressing the authority of a city to tax vehicles that were already taxed. That's not the only thing that case is addressing. That is not the only thing that case is addressing. They're telling you what they can do and what they can't do. The Hendricks case notes that the absence of federal legislation leaves the power. I disagree with that. It depends on what you're talking about. So if you don't mind, if it's not too much to type, can you type it for me and, just put some context behind it, put some substance behind it so I can see what you're talking about? But that's one thing that the Collins case addressed. Yeah, But that's not the only thing that they flat out told you that you can't tax it. They flat out tell you that you cannot tax a right. They flat out tell you that the use of the public highways is a right and not a privilege. They addressed a lot of stuff in that case. That's not the only thing, though. Oh, boy. Okay, I'm going to get off in like 30 minutes, y'all. Let's see. Okay. All right. Now I'm gonna do something else for you, Steve. Excuse me. This is the Collins case. I'm gonna close this out. I'm gonna close this out. This is from 1927. Where's that Texas case at? A lot of cases cite this. This right here. Where is it at? Ex parte Dickey. So does this case. I think there's another one. So let's go down here. All right. Transaction. Exercise the right to travel the public highway. All right. I think it's right here. This is one of it. Right here. I'm just gonna read y'all some sections of it. It is of consequence. It is of consequence here to note that there is a wide distinction between the incidental transaction of business and the exercise of the right to travel the public highways in the ordinary way, and the right to use such highways as a place of business, as a place upon which to conduct business. While the right to use public highways for ordinary travel or use, and incidentally, the transaction of one's business is a common privilege of the public, the right to use such highways upon which to conduct business or to put such highway to some peculiar, special, or exceptional use in order to conduct or maintain business thereon is always subject to the will of the state or the political subdivision, aka territory, thereof, to which such power has been delegated in administrative agency. It is, of course, a well-settled and generally accepted rule that corporate territorial municipalities may not prohibit occupations or businesses lawfully under general laws. Though, generally speaking, they may license and regulate under authority of legislative grant. Whether one in pursuit of a lawful business or occupation may put the public highways to a peculiar or exceptional use, that is to say, conduct his business exclusively thereon, is a widely different matter. Certainly, the citizen has no common or inherent right in that respect, because the streets does not belong to just you exclusively. No, you can't do that. Let's see. Let's get down to where it says should be down here, right here. It might be on that one. It might not be in this one. I thought it was in here. It might not be in this one. It must be in the other one. So let me close this one. It's probably in the other one. Let's see. Nope, not in that one either. Let me just go. I guess I'll just go to ex parte Dicky. This case right here, y'all. This case right here, they were trying to say that a bicycle is a vehicle, motor vehicle. This is the funniest case that I have. This is the case right here. Let me show y'all. Right here. This is the case right here. See this? 112-654. It's an Alabama Supreme Court case. There it is right there. You see it, 112-654. Just so y'all won't think I'm just making stuff up. The volume is 112. This is page 164. This is Davis versus Petronovich, or whatever you want to call it. Anyway, this is what a driver is. This is where they get the definition for driver from, all right? This case and Isaac versus Railroad, that case. All right, that's where they get the term driver from. Now, I want y'all to pay attention because this case, this is how you got to know how to read cases. This case does not say that in here anywhere expressly. It doesn't say it in there expressly. It implicitly tells you what a driver is. I read this case. It doesn't say it expressly. It implicitly tells you what a driver is, and then that allows you to make a reasonable conclusion at what a driver is. But I think there was a kid in here. He was using his bicycle, and they tried to say that his bicycle was either a vehicle or a motor vehicle, something like that. Let me see. Where is it at? Bicycle. What is regulation of use by state? A bicycle is included within the definition of a carriage or vehicle and is subject to like regulation. See what I'm saying? See this shit right here? It's a damn bicycle, though. These are the types of games that they play. This is why you got to go and read cases. Let me close this out and get back to what I was going at, because I'm not sure if he's familiar with what I'm trying to find out and show him. That's not it. Let me go up here. All right, it's that one. Sporte Dickey. Must be the only one. So it's really, there's a few other ones. There's some more cases that actually cite it, but I can't find it. Well, this one does too. Let me see. I'm just gonna read Ex parte Dickey. I was trying to find the other one, but it's just taking too much time. All right. This case hasn't been overturned, by the way. I actually found a case in the West Virginia Supreme Court where they were making fun of a dude for using this case in support of his argument as a right to travel or whatever. And at the same time, while they're making fun of him, they're omitting some case citations in this case, and they do not overrule this case, even though they had the authority to overrule it. I have that video somewhere on my channel. Where is it at? I'll be on here somewhere. In them, also the union on the equal degree and the use regulation and all this thing cannot discriminate. But as regards unusual and extraordinary rights respecting, I think this is it right here. Yeah, this is it. So right here, it says the right of a citizen. I hate using that word, and they got a lowercase. Cause what kind of citizen? You talking about a corporate citizen? I believe that's what they're talking about. Corporate citizen and a so-called natural person. These are all legal fictions, by the way. But anyway, the right of a citizen to travel upon the highway and transport his property thereon in the ordinary course of life and business differs radically and obviously from that of one who makes the highway his place of business and uses it for private gain. You can't do that. You don't own the fucking highway. In the running of a stagecoach or omnibus, you can't do that. The former, the ordinary right, in the usual and ordinary right of a citizen, a common right, a right common to all, while the latter is a special, unusual, and extraordinary. As to the former, the extent of legislative power is that of regulation. But as to the latter, its power is broader. The right may be wholly denied, or it may be prohibited to same and denied to others because of its extraordinary nature. Now, when they say regulation, yes, there's certain shit that they can regulate. And there's certain shit that they can't regulate. And one of those things that they cannot is tax you for that. No, they can't do that. They can't require you to have a license to use the public highways because they don't own the fucking public highways. They can now, if you're using it for private gain, but if you're just using it just in the ordinary manner based on all the cases that I've read, then yeah. Oh boy. I don't even know why I'm still talking about this, to be honest with y'all. But I guess this is what people want to talk about. The Utah Supreme Court voided Amendment D when it found the legislature did not follow the state constitution's requirement that proposed amendments be published in a, not sure what that is. I agree with that, Chip. I agree with that. To be honest with you, like it's a fundamental right, So to be honest with you, these rights come from God, and they generally exist independent of the Constitution. But once you make yourself, or once you accept either the so-called citizenship or whatever of a so-called government, then there are some rights, or some sovereignties or some liberties that you are surrendering. That's why in a municipality, in their corporate territorial jurisdiction, generally speaking, you can't do what you want to do. If you want to do what the hell you want to do, you need to get out of the corporate territorial jurisdiction. Constitutional amendment was declared void by a district court on October 9, 2024 for failing to be properly noticed as required by the Utah Constitution. The proposed amendment. Okay. Next time, y'all, I try to have a call-in number, y'all. Try to have one. It is no private individual. What the hell you mean individual? What's the individual? Man, these words, y'all. These words be scaring the shit out of me, y'all. Scared the hell out of me. I don't know what these people talking about. Sorry, I'm checking my messages. On my phone, I got all these people texting me and shit. Scroll up. Let me see. I think he might have found it. Let me go and see if he found it. Because I sure want to put it on here. Go to my email. Let's see. Volume 113. It looks like, okay, so I think the date you gave me in the original was wrong. This says June 12th, 1967 to June 20th, 1967. Let me see what this other one said. Yeah, this one said June 13th. So it looks like, I mean, you would think that it would be in here though, but I guess it's not. Let's try it again. There it is right there. Right then, just clear as day. Let's see. It's right there. Resolution of protest adopted by the following state legislature. The New Jersey legislature, by resolution on March 27, 1868, protested as follows. The said proposed amendment, not having yet received the consent or agreement of the 3/4 of the states. Look at this, states. You got a lowercase s. I don't know what they talking about, y'all. Which is necessary to make it valid. The natural and constitutional right of the state to withdraw its assent is undeniable. That it being necessary by the Constitution that every amendment to the same should be proposed by 2/3. Let me see, by 2/3 of both houses of Congress, the authors of said proposition, for the purpose of securing the assent of the requisite majority, determined to and did exclude from the said two houses 80 representatives, god damn, from 11 states of the Union, upon the pretense that there were no such states in the Union. But finding that 2/3 of the remainder of the said House could not be brought to assent to the said proposition, they deliberately formed and carried out the design of mutilating the integrity of the United States Senate, and without any pretext or justification other than possession of power without the right, and in palpable violation of the Constitution, ejected a member of their own body representing this state, and thus practically denied the New Jersey its equal suffrage in the Senate, and thereby nominally secured the vote of 2/3 of the said House. The Alabama legislature proposed against being deprived of representation in the Senate and U.S. Congress. The Texas legislature by resolution. The amendment. Arkansas, Georgia. Damn. How can this still be on the public record? And they still do, like, you just ask yourself that, like, how can this be on the public record and they still do this? Unless they're operating off of the presumption of, let me show y'all what I'm talking about. Let's see. I read some cases on this just to let y'all know. Let's see. 81. The authority of a de facto official cannot be collaterally attacked. Let's see why. And the acts of a de facto officer cannot be collaterally attacked or set aside. So I'm going to read y'all some cases on this. Just something. Not too much because it's almost time for me to go. While the authority or title of a de facto officer cannot be collaterally attacked, such de facto status is not a defense against a quo warranto proceeding instituted by the sovereign authority. So they saying you can't really attack what the officer did, but the de facto status can be challenged by quo warranto. That's what they're saying right there. The acts of an officer de facto cannot be collaterally attacked. So you still can change. I mean, you can't tell you can't change the government because they're not sovereign. I don't give a damn what they say. They're not sovereign. Read something from this principle here. All right, here's one right here. They're recognizing this principle. Holding that the appellant, by failing to object to the commissioner's authority before or at the administrative hearing, waived any challenge. Let me go right here. Without citing any, I'm trying to find that principle. All right. The tenure given a police officer is a constitutionally protected interest requiring the opportunity of a fair hearing conducted in good faith before a full and impartial body. Although such proceedings are not subject to all of the procedural safeguards afforded at trial, it is evident, as our courts have held, that the procedural standards should be at the highest level workable under the circumstances, and that the fact-finding process should be free of suspicion or even the appearance of impropriety. Any decision of an administrative board predicated upon a hearing devoid of the requisite requirements is illegal and void. One of the requisites of a fair hearing is that the administrative board have a legal quorum. Let's go down. Where are we at? Trying to find it. I probably should have typed in this word right here. De facto. Let's see. Where is it at? Where is this principle? I think it's this right here. It is equally well settled, however, that the authority of one who acts as a judge de facto under color of authority cannot be collaterally attacked. Any objections to the authority of an attorney appointed to try a cause must be made at the time when he assumes to act, or they will be deemed waived on appeal. In the present case, the judge pro tempore, or however you pronounce that, was acting under color of authority, like statutes, stuff like that, pursuant to his appointment as a judge pro tempore, and as such as a judge de facto, if not a judge de jure. Any challenge of his authority to so act should have been made at the time irregularities occurred and may not be raised for the first time on appeal. The city cites several cases addressing the actions of other de facto public officers. Defendant challenged eligibility of jury commissioner on residency grounds. Qualifications of a jury commissioner or other public officer cannot be collaterally attacked. Where are we at? Right here. Right here. Here we go. Right here. We also find instructive the following language in Carty versus State. This is a principle that they're talking about, in which defendant asserted for the first time on appeal that the county sheriff did not have any statutory authority to appoint the special deputy whom defendant was accused of battering. He probably didn't have any statutory authority, but he might have had some type of common law authority if it was the sheriff. Anyway, one who holds office under color of election or an appointment and discharges. So once he holds that office and discharges the purported duties of office in full view of the public without being an intruder or usurper, is at least a de facto official. So they're saying anybody, let me rephrase that, anyone who holds office under color of an election, under the appearance of an election or an appointment, and discharges the colorable duties of office, or in other words, the appearance of duties of office in full view of the public without being an intruder or usurper, is at least a de facto official. The authority of a de facto official cannot be collaterally attacked. The validity of a de facto officer's acts may only be challenged directly against the individual who purports to hold office. For the protection of the public who deal with him, the acts of a de facto officer are as valid as the acts of a de jure officer. This is equity we're talking about here. All that is required to make an officer de facto is, pay attention to this shit, y'all, that he claim the office, be in possession of it, and perform its duties under color of an election or appointment. Y'all see this shit here? Oh, boy. This is probably why when people are, I guess, squatting in people's houses, they can't put them out. It's probably one of the reasons, if you want to call it that. I'll read that again. All that is required to make an officer de facto is that he claim the office, be in possession of it, and perform its duties under color of election or appointment. If their election or appointment were valid, they, de facto officers, would be de jure officers. A person whose election is irregular and void because he is ineligible is nevertheless an officer de facto if he discharges the duty of his office under color of an election. They're saying nobody is complaining about it. Nobody is complaining that you're just going to let me do it, so I'm just going to do it. You can't sleep on your rights. You can't sleep on your rights. Crazy, man. I'm going to read up some of these comments. I felt bad for him and his dog, so I got in touch with him. Hold on, I must be missing some comments. Probably am. I can neither confirm nor deny that the suggestion came from me. I'm asking amendment as a whole or just a section. Oh, are you asking Void? I mean, was it Void? Oh, I forgot your name. I can't pronounce your name. Are you asking me a question, or are you asking somebody else in the chat a question? I'm sorry. They dropped all the charges except resisting, since you can be charged with resisting there even if the arrest is unlawful. I don't know about that if the arrest is unlawful. Depends. And how would that be? He worked out an agreement to get a license and register his motorcycle. The truck that he was pulled out of wasn't mentioned in the deal and still doesn't have a plate. Notice United States of America at the top, not United States. They're evil. Constitution, that's awesome. All right, y'all. I'm gonna get on up out of here. I'm tired now. All right, if nobody have any more questions, I'm gonna go ahead and get on up out of here, man. And I'm about to lay down, check my investments out, check my cryptocurrency investments out, and I'm gonna get on out of here. I need to listen to this again. Can't concentrate this evening, but I know there's something here that I need for me and a few men in my life. Always something great here. Thank you, Ms. G. I appreciate that. All right, y'all. Well, I'm gonna get on up out of here. And I don't know when I'm gonna do another one. I got a headache, kind of just from doing this one. But next time I'll let y'all know when I do another live. Just send the information over that you want me to talk about or review, and I'll go over it. How long till lashes? I think that's a question of law. I think the question has already been answered. Let me see if I can answer that before we go. I'm just freestyling this off the top of my head, okay? Lashes begins to set in once a party. I don't know if this is. I don't know if anything is going to come up. I'm just trying to see. Yeah, but I mean, I think lashes is It seems like there's just a statute of limitation. Let me see. Defendants argued in its motion to dismiss if the court found Bell's claims were not barred by statute of limitations, the court should find them barred by the doctrines of lashes. To prevail on the defense of lashes, a defendant must prove unreasonable delay by the plaintiff in bringing suit and prejudice to itself caused by the delay. Okay. There's the standard right there. I just read that. Like I've never seen that before, but that seems to be the standard at when the lashes sets in. So it seems to be since the defendant in this case, since he's making the claim that you would be barred by the doctrine of lashes, he has to prove it. And it says a defendant must prove unreasonable delay by the plaintiff. So they have to prove that you unreasonably delayed bringing your claim and prejudice and that unreasonable delay that you had in bringing your claim, it prejudiced the defendant. Something like that. Let me see something. Similar to a statute of limitations, which, like I just said, lashes functions as a temporary limitations on a party's right to sue. It stems from the principle that equity, like I said, aids. Are y'all paying attention to this, man? All they did was they just incorporated all this stuff into one rules of procedure and into let me show y'all what I'm talking about before I go up out of here, man. Let me go to Federal Rules of Civil Procedure and show you what I'm talking about. It's going to be under Rule 12. Right, what affirmative defense is at. Right here. This isn't it. Right here where it says how to present defenses or whatever, even though it doesn't say lashes right here, you can plead lashes in here. All right. They just adopted all of this into the Federal Rules of Civil Procedure. All of the equity rules, that's what they did, man. All of it. I'm trying to see if I can answer your question though, but it stems from the principle that equity aids the vigilant and not those who slumber on their rights. Do not sleep on your rights. So let me see. Lashes is an equitable doctrine which bars action based on an unexcused delay, which has prejudiced an adversary. The elements of defense of lashes are a unreasonable delay. Matter of fact, let me see if I can answer this precisely for you. What state would you like for me to find the elements of lashes in? Void or void. I mean, I don't even know how you pronounce that. Which state would you like me to find it in? And I'll tell you your state's elements. He might be asking that, but he can't. If that's what he's asking for, it says is void or void asking about lashes to void an old amendment. Okay, so Utah. If that's what he's asking about, I don't think he's going to be able to do it by himself. It's extremely unlikely that he's going to be able to do that by himself because everybody else they're complacent in it. And yeah, you sovereign too, and they are sovereign to to a limited degree. But I mean, you just got to respect their right to be ignorant and complacent if that's what they want to do, and you just need to leave because you can't do it. Utah, okay. Um, Elements of the defense of lashes. Copy and paste this. And we are going to go to Utah. Let's see if we can get the elements. Okay, so in Utah, according to the Utah Supreme Court, there seems to be two elements, but let me double check to make sure. The statute of limitations and lashes are affirmative defenses which must be pled. Okay, here's a one from 2020, so I'm assuming that they are two elements. I mean, but it's going to be the same thing pretty much everywhere, to be honest with you. The elements, they might be a little different, or they may be, some states might require more elements than others, but some of the elements are generally going to be the same. The doctrine of lashes has two elements. Notice you see this case right here. This is a 2020 Utah Court of Appeals case. One, a party's lack of diligence, and two, an injury resulting from that lack of diligence. Cleaned up, as our Supreme Court has explained, lashes is based upon the maxim that equity aids the vigilant. Didn't I just show you that in another case? And not those who slumber or sleep on their rights. Don't sleep on your rights. As soon as you find out that you have a valid cause of action and you can pursue that cause of action, you need to just go and sue their ass. Don't wait. The equitable doctrine of lashes is founded upon considerations of time and injury. Lashes is legal significance is, let me see, lashes in legal significance is not mere delay, but delay that works a disadvantage to another. And that's the equity jurisprudence right there. Let me see. Am I helping answer your question? I'm probably not. What kind of different lashes and I did not see what you were saying. Let me see. What kind of different lashes? And I did not see what you were saying. I wish I had a call-in number for you, man. I'm sorry, man. It says what kind of, I don't understand your question. You said what kind of different lashes? I'm not sure if I understand your question. Maybe I said something wrong or something. I don't know. What do you mean? It was probably, you're probably talking about the federal rules of civil procedure, what I was talking about. To successfully assert a laches defense, a defendant must establish both that the plaintiff unreasonably delayed in bringing an action and that the defendant was prejudiced by the delay. So there's the element. So in the Utah, there's two elements. I'm gonna see if I can read some of this stuff for you, man. I am a little tired though, but I'm gonna see if I can help you out a little bit. All right. All right. The commissioner alternatively determined that the principle of laches barred mother from recovering expenses incurred prior to April 2005. So we're gonna get to what they talking about. To successfully assert a laches defense, a defendant must establish both that the plaintiff unreasonably delayed in bringing an action and that the defendant was prejudiced by the delay. The length of the delay that constitutes a lack of diligence depends on the circumstances of each case, because the propriety of refusing a claim is equally predicated upon the gravity of the prejudice suffered and the length of the delay. This issue is therefore highly fact-dependent, requiring consideration of the relative harm caused by the petitioner's delay, the relative harm to the petitioner, and whether or not the respondent acted in good faith. Let me see if I'm probably not answering your question. So does it apply in only? No, laches applies in civil and criminal cases. Equity applies in all jurisdictions, whether it be common law, admiralty, or maritime, and obviously equity. Void, you pasted something about an amendment being void, but it was cut off. Do they have an issue with the Utah Constitution, a statute, or a judgment? So only when harm. Yes. And the burden is not on you, it's on them, because they're making a claim that they were harmed. So the burden of proof is on them. They have to prove it. So only when harm, yeah. So it's like how do I think the laches defense would go along with the with the equitable the equity principle, where you can't sleep on your rights, and there's another one is I forgot the other one. I'm sorry, I forgot. Well, excuse me, it's past my bedtime. I know y'all like it's early, but I'm getting sleepy. So I'm gonna get off here, y'all. I'm tired. Anyway, I hope I helped you, man. If not, I'm sorry. I'll try to get you next time. I'm gonna go ahead and get on off here. Y'all enjoy y'all evening. I'm tired. I'm gonna get on off here. Supreme Litigant is out. Good night, everybody.